All right, good morning, you guys. This is for U.S. government, and what we're doing is we're going to look at the Judiciary posted PowerPoint that I have in the Unit 2 on the branches of government. Anyway, if you open that, what we want to cover is, first of all, I want to get you to down into the slides assessing the role of the federal courts. What you got to remember, first of all, of course, looking at the slide assessing the role, Congress, where it says Congress enacts law, the executive branch enforces the law, that's the president, and the judicial branch interprets the law. So that's the separation of powers. We've talked about it a lot, and that's what that key, or the Alvarez case we were talking about, was dealing with, that separation of powers. Now, judicial review, the power to rule on constitutionality. You've heard this before. Marbury versus Madison. John Marshall established this. Now, it's the power to rule on the constitutionality of the laws of Congress and actions of the president or anybody in the executive branch, depending, could be anybody in one of the executive departments. So that's what we're dealing with. And when we're talking in the Alvarez case, just to make sure, just going back a little bit, what court packing would do was put a whole bunch of people of one view or another, the views we're about to talk about, on the court so that the court then sides with either the president or Congress. And that's what the founders did not want. They don't want a judicial branch interpreting the Constitution the way that a president or a Congress wants. They want a judicial branch that interprets the Constitution, or rather interprets actions of the president and laws of Congress as to whether or not they're constitutional, whether or not they fall into the powers given to them by the Constitution. Okay, so, and if you scroll down a little bit, we're going to get into approaches to legal interpretation, whether you're a judicial activist or you believe in judicial restraint. Okay. Now, most people would say that the founders originally intended for everybody to have a little judicial restraint, although admittedly, just the power of judicial review is not specifically mentioned in that format, but was interpreted as necessary by the Constitution. So that was kind of a liberal interpretation at the time. Okay, so getting to judicial restraint, things you need to know. In this theory, it encourages judges to limit the exercise of their own power, to not start trying to make law. Okay, they're not policy makers. A lot of people think that in going through the court system when it gets to the Supreme Court or even to the federal judges, that they can actually make policy from there. Judicial restraint would say no, that is unconstitutional. It's not our role. We're just ruling as to whether or not Congress can do something or the president can do something, and we need to restrain our own actions. Now, it's mostly a conservative ideology, as you're scrolling down and you can see. Gibbons versus Ogden, good case for that. They looked at the interstate power given to the federal government and said, no, sorry, in this case, even though New York had given a monopoly, we can't uphold that because they don't have the power to do it. That's not a state power, it's a federal power. So they gave that specifically, or they interpreted it specifically from the Constitution and ruled accordingly. Now, judicial activism, on the other hand, says that as a judge or a justice, you're looking at the Constitution or actions of the president and or laws of Congress. Sure, that's fine. But what do you believe also? What do you think needs to happen? And if it's not specifically in the Constitution, are you still going to allow it? Is it still okay? Is the Constitution a living document? And can we allow it? So it allows for personal or political considerations, and it's often called legislating from the bench. As you scroll down, you'll see that. Judges who rule based on their personal or political feelings, political mostly, rather than interpretation, are essentially accused of legislating from the bench. Anyway, that's where we're going to stop. We're running out of time.